did want to introduce our speaker, Ben Mazer. He's an attorney with Coolidge Wall. He is going to present today on the Pregnant Workers Fairness Act for the requirements for the employer. So Ben is an associate in the Labor Department with Coolidge Wall. He's previously served as the assistant prosecuting attorney in Montgomery County, where he managed his own caseload of high-profile political subdivision and class action lawsuits. He also has significant experience with personal matters, Title VII litigation, FMLA, and workers' compensation cases, and arguing before the Industrial Commission. Many of you have maybe been in that situation with your BWC claims in the Industrial Commission. So prior to that, Ben worked at a Cleveland law firm where he represented national leaders in the area of creditors' rights and advocated for his clients in court mediation, settlement conference, and hearings throughout the Northeast Ohio. So with that said, I'm happy to introduce Ben.
Thank you. Well, good morning, everyone. Thank you for having me here today. We're going to be talking about the Pregnant Workers Fairness Act. As you know, all lawyers like a good disclaimer, so before we dive in, this presentation is for informational purposes, right? So this is not legal advice. A lot of what we're going to be talking about today is very fact-specific. It can be very complex. So if you have questions that are specific to any situation that you have with your employees, obviously consult with your legal counsel and make sure that you're going about the considerations in the right fashion, right? So with that said, though, let's jump on in. You know, the first question is, what is, right, the Pregnant Workers Fairness Act? And this is relatively new. So, you know, maybe some of you haven't heard about this yet. Maybe some of you have heard, you know, snippets or, you know, some information here and there on blogs that you follow. But, you know, if you're not familiar with this, that's okay. It is relatively new. So this is a federal law, right? So this is on par with the ADA, your Title VII, your FMLA. This is a federal law requiring covered employers to provide reasonable accommodations, so some of these words are going to be familiar to you, to a qualified employee or applicant. So that's important, right? This is not just necessarily employees. These are also folks that are applying and have not yet been hired, to their known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. And the next part here is kind of going to be familiar to you as well because of the ADA probably, unless this accommodation will cause undue hardship on the operation of the employer's business. So that's a lot of legalese, right? That's like, it's very dense, but we're going to break that down. So pretty much all the words that you see that are in bold, those are legal terms that have been defined by the EEOC, and we're going to break that down in the following slides. But some of that language is probably familiar to you if you're familiar with the ADA. And there are some similarities that we're going to be discussing here between the Pregnant Workers Fairness Act and the ADA. Okay, so how did we get here? And this is just a little bit of a background. In June 27 of last year, so this has actually been in effect almost for a full year now, the Pregnant Workers Fairness Act did go into effect. Shortly after that, in August of last year, the EEOC published its proposed regulations. And these are the regulations that the EEOC is giving you in advance. Well, in this case, it's a little bit after it goes into effect. But they're letting you know what they're intending for the Pregnant Workers Fairness Act to require of employers. They're proposed. The federal government and the EEOC, they do this with pretty much all their new legislation that's coming into play. And they also welcome opportunity for commenters, for public comment from employers and employee interest groups. And they take those into consideration. In this case, they got over 100,000 public comments. I will tell you, really, anybody can submit a comment, you know, just in general when these opportunities arise. I know in the past, our law firm, Coolidge Wall, has submitted comments on behalf of our clients, which are generally employers, basically just advocating for the employer's position or perspective on new legislation, new laws that are coming into effect. But anybody can do that. Obviously, the federal government gets comments from both employee side and employer side, so it's, you know, it's relatively balanced in the sense that they're getting comments from everybody. And then this is what's really relatively new. Actually, in April of this year, the EEOC, after taking into account all the comments that they received, they issued their final regulations. So these are going to be the final rules. This is how the EEOC is going to be interpreting this. If somebody brings, if somebody files a discrimination claim, somebody files a lawsuit, we now have the final rules that the EEOC intends to apply when looking at the Pregnant Workers Fairness Act. And then the last bullet here, June 18th, just 2 days ago, those final regulations did go into effect. So this presentation today is timely. This Pregnant Workers Fairness Act has been in effect now for just about a year, but we just received the final guidance. It seems kind of backwards. It always kind of interests me that, we're getting kind of how they're going to interpret, the laws, almost a year after they went into effect, but that tends to be how this works on the federal level. The first question is, right, who is covered by this? So not all employers, not employees are going to be covered by this new federal law. So the answer is, on the employer side, it is private and public sector, local municipalities, governments as well, with 15 or more employees. So if you're operating at less than that, you're going to be exempt from the requirements of the Pregnant Workers Fairness Act. This mirrors the ADA. So if you're already I have to comply with the ADA, then you're probably also going to be needing to comply, right, with the Pregnant Workers Fairness Act. So that number is the same as the ADA. And what employees and applicants does it cover? I could have inserted the word qualified there, and we're going to talk more about this, but qualified employees and applicants who have known limitations related to, as we mentioned, pregnancy, childbirth, and related medical conditions. And we're going to be talking about those underlined terms or phrases more. So we call this the alphabet soup, right? You have Title VII, you have ADA, you have FMLA, now you have PWFA. A really fair question is, why do we need another act? Why do we need another federal law? How does this differ, right, from the ADA, which, this already sounds pretty similar to, right? So just to kind of hit on an upper level, understanding of what these are, and most of this may be known to you depending upon how much you do in this area, but, Title VII prevents employers from discriminating against employees based upon protected classes, essentially, right? So your religions, your ethnicities, your races. It does currently include both disability and pregnancy. So you cannot make an adverse employment action on the basis of somebody's pregnancy. So that has already been amended, Title VII, to include pregnancy discrimination. In the pregnancy discrimination, it falls under essentially sex discrimination. What's interesting, though, right, is Title VII does not require accommodation. That's where we get into the ADA, which does look at and prohibit discrimination on the basis of disability, and it requires you to accommodate somebody, a qualified individual with a disability. And that's something that you may be familiar with. So your question may be, and it's a fair question, right, why, if we have the ADA, why do we also need the Pregnant Workers Fairness Act? So there are some distinct differences. First of all, pregnancy itself and most of the symptoms related to pregnancy under the ADA are not considered to be disabilities. And we're going to talk more about that, but in fact, the ADA has a different definition of what is a disability than the Pregnant Workers Fairness Act. So the ADA requires for it to be a disability that your condition or the employee's condition be a physical or mental impairment that substantially limits a major life activity. That is not the threshold for the Pregnant Workers Fairness Act. The Pregnant Workers Fairness Act has a much lower requirement than the ADA on what constitutes something a medical condition that has to be accommodated. So that's one important distinction. As I mentioned, under the ADA, pregnancy itself, right, is not a disability. With that said, right, we can think of certain conditions that a pregnant individual could have that arise out of their pregnancy, high blood pressure, for example, maybe migraines. These could constitute disabilities under the ADA. So point being, right, there is certainly the opportunity here, the possibility that you're going to have, when you're going through an analysis, right, with your employee, you may have some overlap, right, between the ADA, the Pregnant Workers Fairness Act, that you may want to be, taking into account and taking into consideration what you're going to be doing, when you decide whether or not you have to accommodate an employee that has a medical condition or a disability. You're going to be looking at really both of these. You're going to be looking at the ADA, does this apply? You're going to be looking at the Pregnant Workers Fairness Act, does this apply? Really the short answer for you is going to be, if this is a condition, a disability, that arises out of the pregnancy, for example, maybe high blood pressure, preeclampsia, that's probably going to fall under the Pregnant Workers Fairness Act. If it's a condition that doesn't necessarily come out of the pregnancy or arise out of the pregnancy, it's probably going to fall under the ADA if it meets the other requirements of the ADA, and you would potentially be accommodating under that. Nobody here, well, maybe some people here do have a medical background, maybe work in a medical field, but certainly not everybody, right? So, it's going to be, and we're going to talk more about this, but for you to make these informed decisions, you're going to be engaging in the interactive process with your employees. You probably already do that with the ADA, you're familiar with that. And under certain circumstances, you're going to be asking for your employee who's made you aware of something that requires an accommodation. You're going to be asking that employee for information from their healthcare provider, right? So you're going to be asking them to provide you some documents from their physician, their nurse practitioner. That's going to help you make a decision, right, as to whether or not this triggers your obligations under these acts, and whether or not the employee is qualified, and whether or not you have to provide an accommodation and what that appropriate accommodation would be. Okay, so we're going to talk more about all this, but this is just kind of laying the framework. So this is really important, right? So what are we talking about here when we're talking about known limitations that have to be accommodated under the Pregnant Workers Fairness Act? And keep this in mind. The Pregnant Workers Fairness Act, right, is broad enough where it's covering a lot of both pre- and postpartum limitations, medical conditions, right? These are defined in the Pregnant Workers Fairness Act by the EEOC. Pregnancy and childbirth includes both current pregnancy, potentially past pregnancy, potential or intended pregnancy, right? So what are we talking about there? We're talking about fertility and fertility treatments. These are conditions that maybe you don't necessarily think of when you think of pregnancy or childbirth, but obviously that's certainly relevant as part of the process. At least the EEOC has said so. So fertility treatments, labor, and childbirth. These are all circumstances that could trigger some obligations for you as an employer if there are, again, here's the next part here, right? The related medical conditions that arise out of those conditions. So these are medical conditions that are related to, affected by, or arise out of pregnancy or childbirth. These are just a few examples, so you can just kind of think about medical conditions or treatments that arise out of pregnancy and childbirth, but these are examples: miscarriage, stillbirth, postpartum depression, termination of a pregnancy, lactation, and conditions related to lactation, gestational diabetes. It goes on and on, right? So these are some examples. These are things that you want to be thinking about if an employee comes to you and says, I have postpartum depression, or I had a miscarriage, I had a C-section. That's when you're like, okay, I really need to engage in the interactive process with my employee and see if we have a duty here to make an accommodation so that employee can continue to perform their job duties. And we're going to keep talking about how you're going to know that you have to do this, right? And as I already mentioned, other conditions, they may not fall under the Pregnant Workers Fairness Act, but the ADA may kick in. As an employer, we're always feeling like we don't have enough information, right? Especially if you're in the HR field. I need more information. I don't have enough information. How do you know somebody has postpartum depression? They may not tell you. How do I know that I have to accommodate it if they don't tell me? When does my obligation kick in if I don't know? So these are known limitations. You only, as an employer, have a duty to accommodate known limitations. And that's defined in the Act. So a limitation is defined as, a mental, physical condition, that's the same there, that is specific to the employee in question. So you may have the question, right, you think about the FMLA, an employee has FMLA rights to take care of a family member, right, who has a serious medical condition. The distinction or difference here between the Pregnant Workers Fairness Act and the FMLA in that respect is that these obligations specific to the Pregnant Workers Fairness Act are only to accommodate the employee herself that has limitations arising out of childbirth. So for example, generally speaking, as a male, husband, you don't have these limitations arising out of childbirth, so you would not be entitled to the accommodations, but your female spouse or whoever's going through the pregnancy or childbirth process, they would be the ones that are entitled to these protections. So not your sister, your sister's pregnant, she has medical conditions. you are not entitled to those protections, your sister is, because she's the one who's pregnant, okay? So what is a limitation? We're going to talk more about that, and when does it become known? So a limitation, and this is where it differs from the ADA, because it doesn't have to rise to the level of a disability, right? ADA, again, is just disabilities that limit a major life activity. A limitation under the Pregnant Workers Fairness Act, it doesn't have to be a disability. It can be minor, it can be modest, it can be episodic. So it's a lower threshold. It may be, right, that I need to go to the bathroom more, right? For example, as you're progressing in your pregnancy, and I only know this because my wife is 8 months pregnant right now, so I've actually learned a lot. This is our first child, but she has to go to the bathroom more, right? You know, the baby's getting bigger, the baby's resting on the bladder. That's not a disability, right? You don't think about necessarily that being a disability, but that is a known limitation, or it will be known if the employee tells their supervisor or HR that, look, I have to go to the bathroom more. I need more frequent bathroom breaks. That's a really good example of something that you wouldn't think of as a disability because it's really not, but it's a known limitation. It's episodic, maybe it's minor and modest. So that's one thing to keep in mind, right? And we're going to talk more about, you know, how you accommodate that. Obviously, in the bathroom case, that's pretty obvious, right? You're going to give that employee more restroom breaks. And when does that limitation become known? It becomes known when the employee or their representative tells you, right? So they have to let you know. If they don't let you know, you really don't want to be in a position where you're guessing. And there's a definition of representative. You know, the employee could have a family member, healthcare provider, union rep, if have organized labor, or another person, coworker. They could also serve as a representative. This is somewhat common sense, but this question, you know, does come up. You know, who does the employee have to tell? If you have a policy, and we're going to talk more about, you know, policies that address this type of stuff. If you have a policy that says, you know, this is who you should tell in these circumstances, obviously the policy will control, but the employee could tell a supervisor, manager, HR. You know, even if your policy says you have to tell one specific person, if somebody else becomes aware, you should probably start the interactive process. Yes, sir?
Do they have to have medical documentation for this?
It's a great question. So we are going to be talking more about that. And the short answer is, obviously, with most situations, it depends. Certain things, and we are going to have slides about this, but certain things the EOC has said are so obvious, right? Let's go back to the example of more bathroom breaks. So you have an employee who has decided to work kind of late into their pregnancy. They're obviously pregnant, you can tell by looking at them. And they say, you know, I need accommodation in the form of more bathroom breaks. The EOC may say that that's so obvious that you know, it's not reasonable for you to require the employee to go to their doctor and say, I need more restroom breaks. But it's going to be very fact specific. So certain things are not going to be obvious, and it would be appropriate probably to request medical documentation from the healthcare provider. One example of that may be, for example, a restriction on how much that employee can carry, right? So a lot of depending upon your industry, you may have requirements that your employees can carry up to 45 pounds. You're in an Amazon factory or, you know, manual labor. So that could be a situation where it is appropriate to say, look, I need something from your doctor that says, what is the safe amount of weight that you can carry? Because I don't know, and I want to get it straight from your medical care provider because that's the best source, right, of that information. So it's going to be very fact specific, and it may depend upon what both the condition is, how obvious it is, and what accommodations are being requested. And that's a really good question, and we will have more slides about that and some examples. So this is really important, and again, this is going to be a little bit of a distinction from the ADA. So the employer applicant does have to be qualified, right? So what do we mean by qualified? And this part of this is similar to the ADA. So that first bullet point up there is the same as the ADA. So a qualified employer applicant is an individual that can perform the essential functions of the job, right, with or without reasonable accommodation. That's from the ADA, and that also applies to the PWFA. And, you know, so what does that mean, right? So if you have, you know, a job description for your employee, there's essential duties probably that are listed in that job description, or they can be, or you're at least aware of what those essential functions of the job are. You know, under the ADA, if somebody has a disability, you have to go through that whole process to see if it's a reasonable accommodation. But if it is, and it doesn't create undue hardship, you have to provide them that accommodation under the ADA to allow them to perform the essential functions of their job. You know, just think about things that, you know, under the ADA, you give employees, it could be unpaid leave. You know, under the ADA, that's one example of an accommodation that you may give somebody, or it could be paid leave. but that allows them to perform the essential functions of their job, assuming that they can return. It's not an indefinite leave. That's true under the Pregnant Workers Fairness Act. However, there is this distinction here where the Pregnant Workers Fairness Act is more expansive, or it provides more protections than the ADA, and it expands qualified employee to those who cannot perform one or more essential job function temporarily. This is not true under the ADA. So under the ADA, there's no requirement that you suspend an employee's essential job function temporarily as a form of accommodation. But under the Pregnant Workers Fairness Act, and I think, the thought process here, right, is pregnancy, for the most part, is more temporary, right? It's not like a disability that probably is, not going to go away. Pregnancy is more temporary, and the postpartum aspect of it generally is more temporary. So the Pregnant Workers Fairness Act says that you are required to temporarily suspend an essential job function, but here's the caveat: it has to be capable of being resumed in the near future. So this is not an indefinite suspension of that essential job function. So let's say, for example, let's go back to that example of you have a worker in your factory who has to be able to carry 45 pounds, right, or more. And that may be an essential job function of that job. You need that employee to be able to do that. The Pregnant Workers Fairness Act says that you may be required to suspend that aspect of their job requirements temporarily. And the key is, at a certain point, the expectation is they're going to no longer be pregnant, and they're going to be able to go back to doing that, right? They're going to go back to being able to carry 40 pounds or whatever the weight restriction or requirement is. So it has to be capable of being reintroduced as a required job duty in the future. And we're going to talk about what that means, what's the future, right? But if it's not capable of being resumed in the future, then that employee is no longer qualified, right? So if you get information from the doctor that says they're never going to be able to go back to carrying the 40 pounds, it's never going to happen. Whatever circumstance would cause that to happen, they may no longer be qualified. And then you have to make a decision as an employer, just like under the ADA. What do you do when your employee is no longer qualified? They're no longer protected, right? So there's always risk there, but maybe you terminate. Maybe if you have another job that's available to them and you want to transfer them, you can do that. But this is something that differs from the ADA, that you may be temporarily suspending the requirement that they carry 45 pounds, even if it's essential. Another example, right? Some of you may have employees that work with hazardous materials or chemicals, right? So think about that in the context of a pregnancy. And I like to try to give examples because it's like, what does this mean? What does it sound like? Well, certain things are easier to think about it than others, but let's say the employee works with paint and it's harmful to pregnancy, lead paint, I don't know, but that may be something that, their doctor's going to say, yeah, she's 7 months pregnant, she can't do that anymore. She's at risk, the baby's at risk, the fetus is at risk. So that would be essential job duty that perhaps you just suspend temporarily until the pregnancy has come to term. So for a current pregnancy in the near future means 40 weeks, okay? So that's what you should be thinking of. It's essentially a full-term pregnancy, but within 40 weeks, maybe that allows them some additional time after pregnancy as well from the start of the suspension, right? So that's when you're going to start counting that clock, right? You're going to start keeping track. If you're in HR, keep track of these things, right? I always recommend, folks kind of document the interactive process, even if it's just an internal memo to yourself. You're keeping track of when the accommodation was granted, so you have an idea of, has it been 40 weeks yet or not? You always got to be careful. They say 40 weeks. Maybe you always have to, say, can I just say on, day 41, all right, it's, your accommodation is over, you're no longer qualified, you can't do this job, terminate them. At that point, that's when you want to kind of talk to your lawyer and say, look, do we want to go back and ask maybe for more information from their doctor and say, look, you've exhausted your 40 weeks. We typically do this with our clients who have employees that are on leave, right, under the ADA. The ADA requires that as an accommodation, so before you can always feel, and even when you do this, you don't always feel comfortable necessarily, there's always risk to terminating. But you go back to the doctor and say, look, you've exhausted the amount of leave that you've been given, the amount of leave that you're entitled to. We need something for your doctor that says, this is when you can come back to work. We need this information. And then you make a decision. The doctor maybe says it's indefinite at that point, or it's another 8 weeks. Well, that's not reasonable, right? So you can feel better about terminating if you have to get to that point. For conditions other than a current pregnancy, in the near future is not given a defined length of time. However, again, and we just talked about this, indefinite leave or indefinite suspension of an essential job duty is no longer reasonable. Nobody's entitled to just an indefinite leave or an indefinite suspension. So keeping that in mind.
I have a question. The 40 weeks, does that mean just like the term of the pregnancy, or like say 6 weeks in to the pregnancy, they come to you and say, hey, I can no longer do this. Do they get 40 weeks from that date?
Great question. Yeah, that's how I would interpret it. So the EEOC says it's from the start of the suspension, so the suspension of the essential duties. So you're absolutely right. You know, there may be a situation where an employee doesn't need an accommodation until they're very kind of late term, 7 months, 8 months. So yeah, if they come to you, in their 7th month and they only have, X amount of weeks to go, but it's less than 40, the EEOC is basically giving them some additional time. So it really would start.
Even if they were to return from their FMLA or their paid leave, they would still have whatever's left to not perform that essential function.
Exactly, yeah. And I think, again, and this goes back to this gentleman's question over here, which is a great question about the medical documentation. Maybe that's a situation where, you get to the end of the pregnancy and, but let's say there's 20 more weeks left on that 40-week clock, right? Well, that's when maybe you go back to that employee's healthcare provider and say, engage in that interactive process again, go to the healthcare provider and say, can, Sarah now perform the essential functions of her job? I need more information to know whether or not I need to continue to accommodate, those additional 20 weeks. It seems like maybe it wouldn't be necessary, potentially, right, depending upon the circumstances. So that's a great question. So we talked about this. This is all very fact specific. What may be true or may be required for one employee who's pregnant and may not be true for another employee that's pregnant. So again, this is all, why we do the interactive process, why we ask for documentation if it's appropriate, so we can make an informed decision about the particular circumstances of whichever employee is, coming to at that time to say, I need an accommodation. And the next couple slides are gonna be reasonable accommodations that you may have to provide or that you may wanna consider. These are a couple right here off the bat. Again, and the key word is temporarily, so again, a lot of this is supposed to be temporary. Temporarily transferring the employee to another job, temporarily assigning lighter modified duty. Maybe you have, lighter modified duty jobs in your company, and that may be in a form of a reasonable accommodation. But again, it's temporary, so the expectation is that they go back to their essential job functions and their normal job after the limitation ends, right? So some of these are really, they're common sense, but it kind of helps to visualize what we're talking about, right? So these are examples of possible reasonable accommodations. Maybe schedule changes are a requirement. Let's say your employee gets morning sickness, as part of their pregnancy, and their doctor says, she does better in the afternoon or midday. A schedule change could be a reasonable accommodation under those circumstances. Obviously, we talked about breaks. Allowing sitting or standing, as you see in that picture there, the cashier, she's sitting. That kind of makes sense too, right, under some circumstances, especially as employees get further along in their pregnancy. Remote work, job restructuring, and again, temporarily suspending one or more essential job functions. As an employer, and this as being true from the ADA, you get to pick what reasonable accommodation works best for you as the employer. The employee doesn't necessarily get to choose, but it still has to accommodate the situation and allow them to perform, under the ADA, perform their essential functions of the job. In this case, perhaps you'll be suspending one of their essential functions of their job temporarily, but they should still be able to perform hopefully most of their essential job functions. So that's kind of the expectation there. But these are different things that you'll be thinking about as you go through that interactive process with the employee and decide what is the best option. Here's some more examples. And again, a lot of these are common sense, but it's like they do make sense. So closer parking, maybe you have a spot that you can designate for them to use so they don't have to walk as far from the parking lot. Time off, and we're going to talk more about time off, by the way. Appropriate size uniforms, if you work in the food service industry or police officer, obviously anything that has a official uniform that your employees have to wear, they're not going to be able to fit in the same uniform probably that they could wear, before they became pregnant as they progress. So that shouldn't be something that you obviously refuse your employees. You probably shouldn't force them to pay for that. You should just give them, a larger size uniform. That's an accommodation. Excusing them from strenuous activities, chemicals, we talked about those. So those are examples. This is really important. So these are 4 types of accommodations that the EEOC has called predictable assessments. I'm not exactly sure what that means, but these are the 4 predictable assessments. And I think by that they mean it's predictable that these are not going to create undue hardship. That's essentially the significance here. So these are 4 examples of accommodations that the EEOC has come out and said the presumption is going to be that this is not going to be an undue hardship for your company or you as an employer to provide your employee that meets all the other requirements. Again, restroom breaks, breaks to eat or drink, allowing an employee to carry water and drink in the work area, and allowing an employee to sit or stand as needed. So you're on the factory assembly line, you may need to give your employee a stool or a chair to sit in if that allows them to still do their job, or you may have to temporarily suspend that job duty if there's other things that they can do. Allowing them to have their water bottle, at the cash register. More bathroom breaks. Now the EEOC, and this is a little bit of a difference from the initial rules that came out. Originally, the EEOC said in all circumstances, essentially, that these are reasonable accommodations and you have to do them. So the EEOC got comments from certain industries, that said, well, maybe this is reasonable for, the Kroger cashier, but our assembly line doesn't allow this to happen. We can't do all these restroom breaks that you're talking about. So the EEOC has said, okay, in most circumstances, 1 or more of these is going to be reasonable, but the EEOC is allowing that certain businesses or industries may not be able to do this, and say that this is reasonable. So in that case, you go through this situation and you say, is this an undue hardship, like you would with ADA? So keeping that in mind, most employers, most industries, though, these 4 things will probably be things that you'll have to provide as essentially per se reasonable, but not all. So engage in that interactive process. If your industry is unique, then you may be able to show that it's an undue hardship. So this is also a difference from the ADA, and this is really important. When we talk to our clients that have employees that have disabilities, one of the tools in their tool belt when accommodating an employee with a disability is you can put them on unpaid leave. And if that's reasonable, even if there's other options, you can jump right to unpaid leave. The Pregnant Workers Fairness Act has said that a leave of absence, whether paid or unpaid, is actually an accommodation of last resort. So you don't get to choose, you don't get to jump to that as an employer if there are other accommodations available. And again, unpaid leave is a kind of a convenient way to handle some circumstances under the ADA. It can still be something that you can use under the Pregnant Workers Fairness Act, but if there are other options available, the leave of absence should not be what you pick. So for undue hardship, the standard is the same as the ADA, so that should look familiar to those of you that kind of work a lot in this area. Undue hardship is significant difficulty or expense for the employer's operation. And I will tell you, when you kind of boil this down and look at the case law, you all may already know this, but it can often be very hard to prove undue hardship on the basis of expense, right? And you all may know this already. And that's still true under the PWFA as it was under the ADA. As an employer, if you're litigating these types of cases, you better hope that you maybe have something other than expense to rely upon, because the courts, the OCRC, the EEOC, they don't often look favorably upon a business and say, yeah, that's too expensive for you, although it may very well be too expensive, right? But really, often you want to say, well, what kind of burden does this place on my personnel, my staff, right? Am I requiring other people to do a million things now because this employee cannot do, what this employee was required to do? Is this forcing overtime? That is both a financial piece, but also a human manpower, right, piece too. So sometimes those are more persuasive arguments, right, to the courts. We don't want other employees to have to necessarily carry the load to the point where it becomes an undue burden. And these are the considerations that you're going to want to review when you're deciding whether or not to allow a temporary suspension of an essential job duty. And there's a total of 6, and you can see them there. But these are, if the temporary suspension of the essential job duty does not satisfy, and the EEOC hasn't said do they have to satisfy all of them. I think it's kind of more of a cumulative, the majority of them. But if it doesn't satisfy the 6 criteria here for the most part, or the bulk of the 6, then it may be unreasonable or it may be an undue hardship, and you don't have to suspend that essential job duty. Yes, ma'am.
One of the examples I can think of when you talk about expense is if you said force overtime, but also if you have to hire another employee to do that specific task. I mean, to me, that would be an immediate expense. That is not reasonable, especially if you're looking at 10 months.
Yeah, you're absolutely right, and I think that would be a strong argument, depending upon all the other circumstances, for this being, for the request being unreasonable. Again, if there's no other ability to accommodate it, there's no other options available, and the only way to accommodate it would be to hire another employee. That could be an undue hardship, and I think that is one of the criteria when you look at the 6. And if you look at 5, for example, and that's the next slide here, whether there are other employees or third parties, temporary employees that can do the job. The answer may be yes, there are, but I have to hire them, and that's going to cost me more money. So that all comes into play. I think that would be a good argument potentially that this would be an undue hardship. I don't have current employees that can do this. I would have to hire somebody. I would be hiring them temporarily. I'd have to pay them maybe more because they're a temporary employee. So that's one of the considerations for sure. Yeah, it's a great question. So I won't read all 6 of these to you, but you have them in your handout. I'm going to go to the documentation piece of this to make sure we cover that, which is the next slide here. So the EEOC has said that as an employer, you can require or request reasonable documentation in this circumstance. And essentially, the EEOC said you can only request the minimum documentation that you need to be able to help you decide whether or not this is a limitation, whether or not this can be accommodated, what type of accommodation is needed, and whether or not this employee can eventually come back, hopefully, and do the full range of their essential job duties. And we'll talk more about what that means, but the documentation that you're allowed to ask for generally should just be documentation that satisfies the basics, the essential information that you need about this. You can ask for documentation from the healthcare provider, right? And that's what we're talking about here, the healthcare provider that confirms the condition. So if it's not obvious, for example, because this could be a mental condition or limitation, often some of the harder things I think as an employer to understand how to manage are the psychological, right, conditions, the mental health conditions. So, if an employee says, I have postpartum depression, that would probably be, appropriate for you to engage in their active process and ask that employee to give you some information, right, from their healthcare provider that confirms that this employee has postpartum, because it may not be obvious on its face. Medical documentation should confirm that the condition is related to the pregnancy, because again, that's the whole point of the Pregnant Workers Fairness Act. Now, if it's not related to the pregnancy or childbirth, obviously, as we discussed, that probably may fall under the ADA, right? If it's a disability, that's when the ADA would kick in. But we want to know that it's related to the pregnancy or childbirth. And then we want to confirm the accommodation that's being requested, right, due to the limitation. So the healthcare provider is really in the best position to tell you, as the employer, what type of accommodation you should be offering. You can get that information for the employee, but if it's not obvious, it's totally within your right as an employer to ask for that employee to get information from their healthcare provider that confirms the accommodations that are being requested if it's not obvious. Okay, and as an employer, here's the important thing: as an employer, you don't want to be guessing what that employee needs, because most of us probably don't have that medical expertise necessary to know what type of accommodation the employee needs for whatever medical condition they have. Here's the one caveat or exception to that rule, and the EEOC, and I think this is new from the final rules that have come out in the last few months, but an employer must accept as sufficient an employee's self-confirmation when the pregnancy is obvious and the employee is seeking one of the predictable assessment accommodation requests, which we talked about. I think this kind of goes back to our discussion earlier on. If the employee is clearly, pregnant, you can see that from the baby bump, right? And the employee is saying, I need more restroom breaks. That, unless it's an undue hardship because you're maybe in a industry where that would be a problem, the EEOC is saying you shouldn't necessarily, under most circumstances, probably require that employee get a doctor's note that says my patient, right, needs more restroom breaks because she is 8 months pregnant. It's capable of being self-confirmed by the employer and the employee based upon those circumstances. So there are situations where the EOC is saying it's not reasonable. And here are more situations where the EOC has said it is not reasonable to ask for medical documentation. I think for the most part, it's the situations where it's obvious. So again, we talked about, number one, we talked about the need for a different size uniform, right? Your employee is now 8 months pregnant. She can't fit in her McDonald's uniform that she used to be able to wear. You shouldn't have to get a medical note from her doctor that says she needs a bigger uniform. It kind of makes sense in that regard. Doesn't always make sense, and not all of these probably do make sense, but some do. When an employee has provided sufficient information to substantiate a no limitation and needs an accommodation. So if the employer is already giving you enough information, that's going to be really kind of specific, case by case. Again, some of these is hard to know. So that, again, you may want to call up your attorney if you have somebody that you like to use for these questions and say, what do you think? Do you think I can ask for documentation under these circumstances? Because it's not always clear cut. But those are 5 examples that the EOC has said it's not reasonable. And we're going to talk more about lactation, pumping, and I've given a whole separate presentation before on the Pump Act, and you may be familiar with that, but I have a slide on that that's just going to touch on that briefly. A request to be able to pump at work, that's going to fall under the Pump Act, which is a federal act that requires that you give your employees reasonable break times to be able to pump at work, reasonable space and appropriate space to use to pump at work. So if an employee is asking for that, the EOC has said that you shouldn't require that employee to get information from their healthcare provider that says this is appropriate or that this is an accommodation that's necessary. So that's one example. And another example would be if you already have a policy that allows your other your other employees to do this, employees that are not pregnant, you shouldn't make an employee who is pregnant go through the extra steps of getting that documentation from their healthcare provider. So those are 5 examples there. These are some best practices, and these are true for the ADA, and these are true for the FMLA. But keep these in mind, right? As somebody, if you're in HR and you would be handling this type of information on a routine basis, you want to keep whatever medical information you get from your employees confidential, right? That kind of is common sense. That goes without saying. This is something that maybe not everyone does, but you should do. Keep it separate from the employee's personnel file. So you can have a general personnel file for that employee in HR, and then you'll want to have a separate file that says confidential, that says medical information, and all the medical information that you get for John Doe, it's put in that separate file. And then this is important too, and this is also true under the ADA, but you want to make sure you're limiting your inquiries to only those that are job-related and consistent with business necessity. So, an example of that would be, if an employee has indicated to you that they have preeclampsia or they have high blood pressure from their pregnancy, you need more information about that, or the employee has said they have, postpartum depression. You want your inquiry to that employee to be really just about that, right? You don't want to be asking that employee to get information from their doctor that's going to give you more medical information than specifically about the condition that we're really focused on trying to accommodate. The second part of that is job related, right? So you're asking whether the employee, based upon that medical condition, right, can perform the essential functions of his or her job. So it should be job related. You're not going to ask wide-ranging questions about a million different things, or you could run afoul of the ADA or the PWFA. So I think we're coming down to the end here. I already touched on this, the Pregnant Workers Fairness Act, and we have the Pump Act. And the Pump Act is just a general overview. This is something that could have its own entire separate presentation, but it applies to both exempt and non-exempt employees. It applies to hourly and salary employees, and essentially you're giving them time up to 12 months after childbirth to pump at work. And that time that you're giving them, this is where the FLSA kicks in, the Fair Labor Standards Act. But that time, if it's short intermittent breaks, it's most likely going to be paid time for them to do their work, in particular if they're hourly. If their salary, as you know, you can only make deductions from pay for salaried employees for very specific circumstances. So it's most likely going to be paid break time for your salaried employees as well that are exempt. And it has to be a separate room. It has to be shielded from view, right, from coworkers and the public. Now, the reason why I'm talking about it, right, as part of the Pregnant Workers Fairness Act, other than the obvious that obviously this kind of goes hand in hand often with childbirth and pregnancy, but the PWFA has specifically said that lactation accommodation is part of the Pregnant Workers Fairness Act as well. And that includes, under the PWFA, which dovetails with the Pump Act, that you provide a space for pumping. It has to be in close proximity to a sink, running water, and refrigeration for storing milk. Again, it still has to be reasonable accommodation. If there are situations where this would be unreasonable for your business to do, you may not have to accommodate that under the PWFA. I think, again, if it's an expense thing, that's going to be harder for you maybe to show as an undue hardship. If it's our workspace doesn't have space for it, that is discussed under the Pump Act. You may have to get creative. You may have to provide an empty office. Do you have to put a sink in there? Maybe you don't have to put the sink. Maybe that's the part where under the PWFA you don't have to accommodate that, but you still have to provide the space. A refrigeration for storing milk, that's part of this as well. So these are things to be thinking about as you navigate the PWFA and the Pump Acts both. So I know we just got a couple minutes left, and I think we're on the last couple of slides here. So what are the penalties, right, if you violate this act? It's similar to Title VII and a lot of the other federal legislation. An employee could get injunctive relief, which is an order from the court that says you have to begin immediately doing what you're not doing, right? And that typically is non-monetary. The injunctive relief is basically just saying immediately you have to start doing what you're required to do. But as we know, a lot of these cases that end up in the court, the employee is going to be represented, right? Or a former employee is going to be represented by an attorney. They're going to be asking for all kinds of money damages. So you're going to have you're most likely going to be getting sued, right? Compensatory damages, punitive damages. And this is really not all clients think about this. Not all of our clients think about this. You have to remind them. If you're successful, they're also going to get attorney's fees, and they're just going to rack up pretty quickly, and they can be sometimes more than what the compensatory damages could be. So there are monetary consequences to this, of course. This is really important and interesting. You do have an affirmative defense to monetary damages if you can show that you made a good faith effort, right, to accommodate and identify reasonable accommodations. So really what that's saying is, again, this is the importance of the interactive process. You really want to go through the interactive process with your employees, document it, do a memo to yourself as the HR person or the supervisor if you need to, and just show that you made a good faith effort, And if you're able to do that, what is a good faith effort? Well, I met with Sarah on November the 12th. We talked about her limitations. We talked about what she needs to be able to do her job. We discussed options. I asked for medical information from her doctor. That is a good faith effort, right? That's what that looks like. So if you can show that you did that, then you should be able to assert an affirmative defense that would say that you wouldn't have to pay money damages, which is obviously important. Last slide here. These are the things that you should be doing as an employer. As I mentioned, this law is in effect now. So these are things that, if you have a pregnant employee that comes to you later on this afternoon and says, I need more restroom breaks, hopefully you now have some information to help you know what to do about that. But this is effective now. These are the things that you want to be doing. Take a look at your current policies. You can update your policies. You can, add them to your handbook. A lot of what you have about the ADA is relevant still here as we discuss. Some of it is in addition to the ADA, as we've also discussed. And this is really the important thing too. Train your supervisors, your HR folks, make sure that they're aware of this. If they're not currently, you may be those supervisors and HR folks that are going to go back and say, now I know what to do. But make sure that everybody that makes these decisions knows about their obligations. So that's everything. My contact information is on the first page, so if you all do have questions after today, any situations arise, please feel free to reach out, and I'm happy to assist, okay? Thank you all for your time and for having me today. Really appreciate it.